Okay, everybody. Well, I think we will get going, and if other people filter in as we get started, that is great too. I'm Sean Randolph. I'm Senior Director at the Bay Area Council Economic Institute. For those of you who don't know us, I think everybody does, but the council is the business organization for the San Francisco Bay Area. We're a business support and public policy organization that focuses on economic priorities in our region and in the state. The Economic Institute is basically the think tank, the research and strategy arm for the council and its partners, and we are always looking intensively at what drives our economy here, not least of which is technology and innovation. So our conversation this morning is around technology and innovation in the Bay Area, but also in California and nationally, and how that may be impacted by an idea that is currently being explored. And the U.S. Commerce Department has been written up in the Wall Street Journal as well as something that's maybe on the table that would significantly change the fee structure for patents, the fees charged by the federal government, and what the implication of that possible change would be for the innovation economy here in the Bay Area as well as nationally. We think it's very consequential, but leave it to you to come to your own conclusion. We have some true experts on this topic today. Scarlett Bickerton, who's the manager for federal and state affairs at SEMI. Bowman Heiden, who's the executive director of the Tusher Strategic Initiative for Technology Leadership at UC Berkeley, and John Manchester, the director of IP policy and of the Global Innovation Policy Center at the U.S. Chamber of Commerce. And the Chamber has taken an active lead in bringing together parties from around the United States who share our interests and share our concern in this particular topic. So we'll go right into it. We're going to try to leave about 10 or 15 minutes at the end for questions and answers. And when we get to that, suggest you use your Q&A function on your toolbar. But getting right in the topic, and I think for our panelists, I think we all have our views on this. So I'll direct a question to one person in particular to start, but feel free to weigh in on anything if you have a view on the subject. So to start off, not everybody is deeply familiar with how the U.S. patent system works. And how the U.S. Patent and Trade Office, which actually has a presence here in San Jose, operates. So let's say you have a technology, a design, you're a startup, you're a company, you want a patent. What hoops do you go through? What does that patent process look like today? And maybe we'll start with you to lead off on that, Bowman.
All right, thanks, Sean. Yeah, so we're going to get into this patent fees or patent tax. So let me just give a quick overview that will lead us in that direction. So first, if you have a patentable idea, you would go to a patent attorney. That could cost between $8,000 to $20,000 to turn your patentable idea into a patent application. But when you go to the USPTO, it's not that expensive. It's a government agency. It's like same type of situation when you get other permits and other types of registrations. So it's the basic filing is only a few $100s, probably a couple thousand in total to the government for your application, and then another maybe $1,300 when it grants to accept it, to accept the application as granted, and then to keep it granted, to keep it going, you pay a maintenance fee to keep it active up to the 20. Well, patents that last for 20 years, but at the USPTO, you only pay at the 3, the 7, and the 11-year mark to see whether you want to continue to pay for your patent to be active. And that's about 2,000 at the 3-year, 4,000 at the 7-year, and 8,000 at the 11-year. So this is relatively modest amount of money in relation to the reason for companies to patent.
So very affordable, generally not a barrier for people who want a patent to innovate and to go forward with their technology. Not a
and it can be cheaper for smaller entities than for larger ones. So these numbers can even go down from there.
Got it. Thanks. And so why do so many people and businesses choose to go for patent protection and especially choose to file here in the US? and what makes our system really attractive for innovators? So maybe Scarlett, do you want to pick up on that?
Yeah, absolutely. Thank you so much, Sean. As we launch into this discussion, I just want to share the position from which I'm speaking to this issue for those who are not familiar with SEMI. I'm in Washington, D.C., and I manage advocacy efforts for SEMI, which is the global industry association representing over 3,000 companies from end to end in the semiconductor supply chain. So there are a lot of patents involved in this industry. To your question, I think the US patent system is certainly not perfect, but it is transparent, rule-based, and globally influential. When we talk about innovation in the semiconductor industry, I think what we're really talking about is the heart of a global economy that runs on intellectual property. So for decades, the United States has been viewed as one of the most attractive jurisdictions in the world for patent protection. And this is including by innovators everywhere, not just by US companies. And from an industry perspective, one of the core reasons is market size and leverage. So the US remains one of the largest and most advanced markets for semiconductor related products. A US patent gives companies the ability to protect their technology in a market that it drives global standards and attracts investment. It also provides negotiating power, right? Like investors and strategic partners recognize the enforceability of a US patent. And when you're licensing technology or raising capital or entering a joint venture, a US patent portfolio carries enormous weight. The strength of the US legal system and a longstanding framework for IP protection here includes, specialized courts, experienced judges, and enforceable remedies. So in a sector like semiconductors, where so much value crosses borders, injunctions, damages, exclusion orders, they're an incredibly powerful tool or tools. US patents have global reach as a result. And I think a filing here often serves as the cornerstone of a company's international IP strategy because of the weight US law carries abroad. American case law and standards, they often set the precedent for how patents or design claims are interpreted globally. And the US patent system allows for, in addition to all of this, also a deeply integrated innovation economy in the United States, because patent rights here, they're not simply a legal shield. They're part of a broader R&D infrastructure that supports critical industries. So the CHIPS and Science Act, for example, allowed for an environment that naturally promotes partnership and patenting through several mechanisms. From a financial standpoint as well, patent ownership it often complements companies' R&D incentives. So patentable activity often serves as evidence or at the very least a strong indicator of innovation activity that would qualify for R&D tax credits and other incentives that reward innovation. So for semiconductor firms investing billions of dollars in research as well as other industries, the benefits of the US patent system are significant.
So really foundational. And especially for us here in the Bay Area, again, it's a national topic, but we generate more patents by a large measure than any other metropolitan region in the United States, including ones that are much, much larger than ours. So it really is bedrock for what happens here in the Valley, as well as nationally. So, John, maybe we can come to you now. So, getting to the topic. So, what is the proposal then that is currently circulating inside the U.S. Department of Commerce?
Yeah, thanks, Sean. And as you mentioned at the top of the call, this is a rumored proposal. We obviously we think there's some fire here. We're seeing smoke, but ultimately we're just going off the Wall Street Journal reporting and kind of rumors we've heard. So I just stress that before I get into my talk. The proposal being floated would require patent owners to pay fees based on a government assigned value of their patents. We've heard anywhere from 1 to 5% of the government assigned value. Obviously, this would be a dramatic shift in the current fee structure, which, as Bo mentioned, is really set up currently to just recoup the costs of running the PTO, meaning the PTO doesn't just assign fees willy-nilly to have a huge bank account that they can spend on other things. They're just charging users what they need to keep the lights on, so to speak. And in our letter, we sent a letter, the U.S. Chamber and others signed on to it, to the House and Senate Judiciary leaders, outlining some issues with this proposal just off the bat. I mean, first, there would seem to be some serious legal overreach. The America Invents Act, which sort of governs what the PTO can charge in terms of fees, is pretty strict in saying that it can only be used to recoup operational costs. So this would be a departure from that. It would be an innovation penalty in a lot of ways. It would punish, you would punish losers and winners, where you spend years and potentially thousands or millions of dollars trying to create something, and then the minute it's successful, the government would slap a pretty hefty fine on top of that. And then, I think there would just be unintended consequences of pushing people away from using the patent system. They would just start protecting their innovations through trade secrets, which has challenges as well, because part of the value exchange of the patent system here in the US is that you publicly disclose your invention and your patent and what you've done. You get a limited time monopoly protection on that. But then it allows other people to hopefully build off of what you've done and create something new and better. If people were to just use trade secrets, that dynamic would cease to exist.
So, Bo, before we get into, I'll turn to you next, Bo. Thanks very much, John. Before we get to the kind of the details about whether this is even workable, what kind of outcomes, I'm guessing pretty negative outcomes, might we expect if this kind of system were to move forward? Because it feels like that would be a big structural shift in orientation toward, let's say, revenue generation for the federal government, as opposed to the current role of patents in facilitating innovation.
Yeah, exactly. So let me just get the ones at the top of the list. So, the basic economics is if you tax something, you get less of it, right? So I don't think we want less innovation. So that's the first question or the first issue. Also, taxing upstream, up on the innovation level, not downstream where the companies are selling their products and services. It reduces the leverage of the economic output downstream, which is why governments often give out R&D tax credits or incentives to reduce tax and increase innovative activity. Actually, the current bill that was passed by Congress has those tax breaks in it, so this would be counteracting that. And then finally, many innovative companies don't rely on the patent system. So it would also be unfair to patent intensive innovators. And yeah, the list goes on. I'll stop there, but we can have more questions later.
I think, Scarlett, you have some thoughts on this too.
Yeah, absolutely. I'm happy to share. Congress has undertaken a lot of efforts to incentivize companies to hold their IP in the United States. They have something called foreign derived income that they're able to cut some tax breaks for. And this is a structure that largely encourages this holding IP in the US and holding and innovating here and continuing to operate here. So I think to Bowman's point that this proposal would undercut that, I think that there's perhaps a disconnect between supporting the administration's goals on onshoring several critical industries and the bipartisan, including in the One Big Beautiful Bill, some of the credits that were extended there. There's a little bit of a disconnect between using that framework to encourage companies to hold IP here, whereas this proposal, as Bowman mentioned, would disincentivize holding IP here and undercut some of those bipartisan congressional priorities.
Thanks. And John, now we're going to go deeper in the weeds. There's this question of valuation. Values of patents, of course, can go up and down over time. They could be worth a lot today and worth nothing tomorrow, depending on how a company develops and the market. So how would the government go about assigning a value to individual patents? And what, just administratively, how would or could that work?
John, show us the math, John.
Yeah, I'm gonna make this is all gonna make sense after I'm done with this after my commentary. Sean, the short answer is I don't know how they're gonna go about this. I don't have a firm sense of where they're gonna go to make this math make a lot of sense. Valuing patents is incredibly complex. It's not like real estate or commodities that have fixed market values. Depends on a lot of things like future market potential, licensing opportunities, litigation risk, and others. And even folks in the private sector that work on these things for a living, and are talking maybe about one patent only, that is difficult for them. So, trying to imagine a government agency like the PTO, which they work very hard to get through their patent backlog they have now, but is already really, really taxed, to use a word we're going to discuss a lot today, tax them to just doing what their regular job. They're going to have to figure out a way to value fairly and consistently across millions of patents. That really would include finding a new valuation framework that would likely need to be industry specific. You'd have to hire a team, hundreds of economists, analysts, legal experts to make this work. Have an appeals process for disputes, because likely people are going to have hard disagreements about what exactly their patent is worth, whether it's worth more or less. And then, continuing to update the value as market conditions change. This would be, as you can imagine, expensive, time consuming, and just incredibly difficult. Not to mention it would just destabilize the patent system as it exists. So a lot of issues there.
Do you have thoughts on that, Bowman? I think you have a lot of thoughts on this topic, but on that in particular?
Yeah, I'll try to keep it short, but I agree with John. The patent valuation is intrinsically difficult, and for many of the reasons he mentioned. So most patents are options on the future. We don't know whether the underlying technology will be successful or not, but we have a control position there just in case. So there is a value to hold those options, but not a realized value. And for those patents that do produce value, do have realized value, the value is primarily indirect through the sale of products and services, not direct revenue generation through licenses or sales. So there's not a market transaction that makes it easy. You have to figure out what is the apportioned value of the patent in relation to other products and other strategies, as Scarlett has spoken about. And then the last point I think is that value, is this going to be value measured in what was produced this year, or is this the total capital value into the future, which makes it a wealth tax in many ways? So each year we're going to take the total value of the whole thing and keep chipping away at it through the tax, which is, you do that for enough years, and of course you don't have much left, right?
Well, you raised an interesting question there about taxes, because companies already pay taxes on their revenues. So it sounds like this is like another level of tax, a double taxation, or a tax on innovation.
Yeah, I think so. Scarlett, do we want to touch on that?
Yeah, I'm happy to. This is one of the concerns that I've heard consistently from across the semiconductor industry, is that imposing additional patent fees, particularly as you highlight, Bowman, those tied to commercial success, would amount to a form of double taxation. Companies pay federal and state taxes on their revenues, which includes income derived from patented technologies already. So adding a separate patent-based fee on top of that essentially taxes the same innovation twice. There are some highly R&D intensive industries, such as the semiconductor industry, but also, as you can imagine, the pharma and defense industries, when R&D spending represents a significant share of operating costs, and margins are often reinvested into the next generation of design and process. So, as a point of reference, a little bit of data in the semiconductor industry, in the ecosystem, in 2024 alone, 52%, over half of earnings before interest and taxes, were invested in R&D. And 70% of senior executives from global semiconductor industries indicated plans to increase R&D spending this year in 2025. So a patent fee creates a disincentive to that activity, and to filing and commercializing patents in the United States. So we look at the incredibly strong and desirable U.S. patent system, and then we look at this rumored proposal, and as Bowman discussed, it's It's been reported that the purpose of the proposal is, at least in part, to support raising revenue to address the U.S. deficit, among possibly other issues under the Department of Commerce's purview. And I think Bowman's comments in the last question, the unintended consequence of this would be that instead of encouraging the very innovation that our patent system was designed to protect, such a fee risks penalizing successful commercialization. And then if you don't mind, a separate point here, I think that it's worth highlighting what we're talking about here also. Patents are not simply legal assets. John mentioned this earlier, but patents are the culmination of years of research, experimentation, and sometimes heavy capital investment. And every semiconductor patent represents substantial sunk costs, the lab work, prototyping, material science, and the workforce that it takes to develop something that is genuinely novel. And so to then attach a fee linked to downstream revenue, or some kind of currently unknown valuation methodology, it indeed overlooks the fact that those revenues are already taxed under the corporate income tax system. So I could spend a lot of time talking about how creating a patent fee structure like this would send the wrong signal globally, as no other advanced economy does anything like this, because it is double taxation. And I think the bottom line here is an emphasis on how important it is for the Trump administration to hear from industry about this proposal. And I think the administration has ongoing concerted efforts to undertake a massive onshoring of manufacturing and critical industries. You've likely seen how this administration touts companies' announcements that they will begin or expand investment in the United States. And these companies are celebrated for that. And the administration very obviously rewards companies supporting its ultimate onshoring, reshoring goal with efficiency mechanisms in place to accelerate these investments and ensure all the inputs necessary are available for standing up a new investment. And I think that this patent fee proposal, it actually undercuts the administration's own objective of bringing manufacturing as well as other critical industries back to the United States. Onshoring depends on sustained R&D investment, and as a result, strong IP protection, not double taxation. I think the administration really needs to hear from industry and understand how adding new patent fees would raise costs, effectively a double tax for precisely the companies that are expanding U.S. production, and it would discourage the innovation that domestic manufacturing relies on. So how the administration facilitates IP policy, I think, will send a message to global investors about whether the United States intends to reward or penalize innovation, which is obviously taken into consideration in investment decisions.
Good insight. Following up on that, and maybe this is a question for you, John, but I'm sure you'll have thoughts too, Scarlett. So what kind of companies would be most affected by this? Because we think about large companies with large patent portfolios, but very often you have smaller entrepreneur-led startups that are starting with a patent, then trying to get a company going, and it may take years before they have revenue. So how do you see the potential impact across a range of companies at different ages, different scales in their development?
Yeah, I can tell you, at the U.S. Chamber, we represent a lot of, companies across industries, pretty much any company you could think of. And we haven't just, on this proposal, we haven't just heard from the IP intensive companies. We've heard from almost any company that even has a handful of patents, because they realize, like we do on this call, that this could have, really disastrous impacts on their business. First off, I would say startups is probably the biggest victim here, which is relevant for the crowd we have here, is that, startups in biotech or clean energy, advanced manufacturing, where patents are kind of the company's only asset. I think they're going to suffer a lot. If you're an investor looking to invest in a startup, and you have this patent fine looming over the startup and the patent, you're probably going to try to put your money elsewhere and figure out that it's a better investment to just do something different. Universities, I'm sure Bo can talk about this, but universities and research institutions that will often license their patents to companies, they're going to be impacted as well, because they would be kind of stuck holding the bag, so to speak, if this idea were to go through. Small manufacturers, a ton of folks. I think you're just going to see people abandon patents or not get involved in the IP in the patent field at all, which will have really disastrous impacts on innovation in the U.S.
Yeah, I could certainly see with smaller, especially pre-revenue companies, how that would affect them. But also, I think from the venture capital standpoint, VCs are looking to invest in potentially high growth companies, and if you have this element of uncertainty about what's this other level of effective taxation on a company as it grows, and that number is going to be by definition uncertain over time. We live to a large degree on venture investment here in the Bay Area. And,
Yeah.
it's a pretty risky, uncertain business at the end of the day, but I don't think investors are necessarily looking for another element of risk in their investment decisions. But universities came up. Bowman, any thoughts about how universities might be, pulled into this narrative?
Yeah, I think the university context is similar to John's early stage uh, context. In fact, it even gets even earlier than ventures, right? So most most universities have patents on early technologies that are not licensed. So they fall into this category of potential value, not yet realized. So you have these patents. They obviously think the technology has a potential value, but it's so early that they don't know yet. Then, of course, you have the patents that are licensed, right? And those are licensed in different ways. If they're licensed to big companies, most of the value is created by the big company. Most universities don't try to make a lot of money, and they don't make a lot of money, um, because the whole idea of the Bayh-Dole Act was to get the ideas out there to be used by American firms that would then make the money and create the jobs. Um, but it is the universities that still own the patents who make a little bit of money, but the people using the patents are making most of the money. And I don't want to give the government any ideas, but that's the wrong end of the stick to tax if you're trying to get the money, right? And then of course the ventures was the one that John mentioned, and ventures haven't realized any real value yet, but on paper they have a lot of value because the venture capitals invest in them. So let's say that they have only a patent as their asset, as John mentioned, but they're valued at say 50 million dollars. Well, then isn't the patent worth 50 million, and shouldn't we get a percentage of that? But it hasn't been realized yet because it could just turn into nothing, or it could. It's a nightmare. I'm trying. You can see I would rather not this take up. I'd rather have this not take up space in my brain. But here we are.
Here we are. Uh,
If
the
I could
topic of
add, if I could add
please,
one
yeah.
thing to this as well, beyond just thinking about what kinds of companies that this could potentially hurt, I would also like to add in the perspective on supply chains, especially from the semiconductor perspective. A lot of the more upstream middle chip makers or even downstream products, they rely on these inputs, the materials, the tools that are used to make or to test the equipment. And even these companies, if they have issues with this proposed fee, it creates ripple effects downstream. And so I think this is where industry input is really important, where SEMI is engaging with the administration and with Congress on it to try to add this supply chain resiliency aspect to the conversation as well.
Well, maybe following up on that a little bit, Scarlett. So in the semiconductor industry, as I understand it, there's a lot of cross-licensing that goes on, and multiple patents might support a single product. So how could that be managed with this
Yeah,
kind
that's
of idea?
exactly right. To paint a picture here, a single chip can embody over 1,000 patented inventions, everything from transistor design, lithography techniques, and packaging processes to the materials and the software and the testing methods I just mentioned. And, it's really hard to overstate the sheer volume of patents that are involved in the semiconductor industry. And I want to be specific here. The density of IP here is not a sign of redundancy. It's a reflection of how innovation happens. This work in our industry is incremental. It is collaborative by nature, as you mentioned, with cross licenses, and it is global. And so each generation of technology builds on prior innovations, and those are held by tons of different entities. So when we talk about a new fee tied to patent ownership or revenue, it's not hitting a few isolated IP assets. It's really hitting the backbone of the entire technology stack. And as I was kind of talking about earlier, that's why this issue cannot be handled in a vacuum. Policymakers really need to hear directly from industry because the patent ecosystem in R&D intensive industries, it's unlike others. For the semiconductor industry, the patent ecosystem is vast and it is highly interconnected, and it's absolutely foundational to US leadership in this space. So, of particular concern to our industry with the cross licensure is that we do rely on a dense web of cross licensed patents. And many patents in the chip are jointly held or licensed among multiple companies across the global supply chain because technology all has to work together. And so, as John highlighted, it's really difficult to determine the value of a patent. This is something I think the government would have a pretty difficult time doing. And, to build on John's comments about valuation, I want to drill down on the point that patent value is largely context dependent. And I think of chief concern to SEMI and our members is if valuation were handled administratively by a formula or through some blanket process, it would almost certainly misprice innovation. The USPTO is famously under-resourced as it is, and patent valuation, it has to be done by those with the technical and commercial understanding to know what IP actually represents in practice. The USPTO currently lacks the staffing and the resources to carry out these valuations. This is why industry consultation will be essential. The people building the technology every day are the ones who are best equipped to evaluate how patents function economically, and any valuation can only be credibly done with direct input from industry because of these cross licenses and the collaboration here.
So this gets into and maybe another question, which is we're not sure where this proposal or idea stands right now, but are there, it seems like the patent system is working pretty well, recognizing that it is understaffed. Are there reforms or changes, putting this aside, that anybody would think would be helpful for the government to consider?
Yeah, I mean, I'm happy to take a first crack. I mean, I think if the PTO or the Department of Commerce or the government want to have a discussion about patent fees, like raising the fees that already exist, maintenance fees, what have you, I think the industry is willing to have that conversation because we all recognize the importance the PTO plays in this system, and as Scarlett mentioned, they're understaffed, under-resourced. They're really trying to build up capacity to deal with all the patent applications they have to work through. So, if it's a discussion about money, and there's other ways to get them the money they need, that's great. But to me, this idea sounds like a way to raise a ton of money off the backs of innovation and then divert it to other things in the government that aren't related to the patent and the IP system, and that's a dangerous precedent that would not be helpful.
Got it. I'm going to encourage folks in the audience, if you have questions for any of our panelists, put them in the Q&A now. We're going to get to them in just one moment. But before we do that, for anybody, is there anything else, within the panel here that we didn't touch on? Anything you'd like to add, or any particular points that you think it's really important that our audience come away with?
Yeah, I would just add, we've all touched on this, that the proposal as it's identified or formulated, I don't think it's going to work. I think the PTO can keep looking at this as long as they want, but they're going to eventually figure out that this just isn't workable. And so I've had discussions with people about, well, what would a different system look like? What would they pivot to? And again, this is just rumor, but it's something that I heard from somebody I think is well sourced on this, is that they would potentially look at kind of a trade association model. And this is another bizarre one, but where, in trade associations, members will often pay a percentage of their gross revenue to become a member. And in this scenario, you would pay a percentage of your gross revenue to then be given the privilege to pay your maintenance fees on the patents that you own. So that to me would seem more like, even though I don't think it's a good idea, I think that's a more attainable thing. So that might be something they pivot to. And I have heard that the president has looked at a PowerPoint about this proposal. So it is something that I think, there's a ton of smoke here. We're hoping that the fire gets put out, but I think there's something here.
Got it. Thanks. Got a couple of questions. Hang on
If
a
I
second here.
could add
Please, yeah.
one more comment here for participants, your input matters here. I'm speaking from the semiconductor industry. You know, we're in the midst of an unprecedented domestic expansion that this proposal could unintentionally undermine. I'm sure it is not the administration's intent to use anything to undermine their own objectives of onshoring industry, right? I think we all on this panel look forward to continuing to communicate with the administration and with Congress about our equities here. And I look forward personally to seeing the actual proposal and having something to tangibly engage on. But I would really highly encourage all of the participants to examine ways to add input in with the administration and their members of Congress on the unique effects that this policy could have on your company.
Thanks, Scarlett. Got a couple questions coming up now. One of them, I'm going to read it here. If valuation is an issue, why not tax at the transaction level as opposed to integrating valuation in the US PTO workflow? So this might have already come up a bit in the conversation, but any thoughts on that?
I can just add to what's been said that we're doing a lot of gymnastics here. We're playing like a game of Twister to somehow not just do regular corporate taxation, right? It's everything we do, we talk about tariffs, but they're taxes. This is a tax. Taxes can be necessary. We run a deficit, but this is not the right end of the stick. And I'm not sure there's any economists that think this is a good idea, and that never happens, or any IP people. And we never always agree. So that tells you something.
There's a follow-on question here. I think this is a really interesting one. Here at the council, we work a lot with scientific organizations because, basic research is really foundational to what goes on in the economy here. And that kind of gets us to Bayh-Dole and intellectual property being generated with support from federal grants coming out of universities. So here's a question from one of our partners who works with universities extensively, and it goes, with respect to universities in Bayh-Dole, Howard Lutnick recently floated the idea that the government should retain an interest in patents arising from federally funded research. So that's a big departure from kind of the spirit and the application and I think the letter of Bayh-Dole. But what would be the interactions then between a value-based patent fee structure and then a government interest in the retention of federally funded research?
Yeah, I mean, I'm happy to take a crack. I mean, we've been at the chamber have been observing the comments about Bayh-Dole as well. I think it's all very troubling. I mean, the examples of Bayh-Dole, the benefit of it are numerous. I mean, you can see how it's a symbiotic relationship between universities and industry, and it just to me seems that the Trump administration is looking for ways to raise money and to divert it towards other projects. And this is just another one of those attempts. And it would have really disastrous effects, as we've outlined on the call. I think your entire IP system risks being dismantled.
I think
Yeah.
that's exactly right. I think also this would be a major policy shift. And my concern with it is it could reintroduce some bureaucracy into commercialization. And I think it also creates a system where if the government both taxes and profits from the same innovation, it sends a mixed signal to the private sector. And there's some practical chaos here, in industries like semiconductors where federally funded R&D often flows into complex cross-licensing networks. The structure even this structure would be nearly impossible to administer. And I think it would still discourage companies from partnering with federal research programs as well if they can't be certain that they will retain full IP control or benefit from commercialization. So any discussion on this, I think especially for my sector, it sits at this intersection of public funding and private innovation, and this is a deeper conversation for maybe another webinar to have.
Yeah, I
Thanks,
can just
Scarlett.
add that there isn't any money there to get. So maybe so that the universities don't make much money because they're not really supposed to. I mean, some of them do, but the goal is to get the ideas out there and let American industry generate value. And then those companies, if they do well, should pay taxes. That should be the cycle. So not only might the government not be the best actor to manage this, which is why the Bayh-Dole was created, there just isn't much money to find there unless you, of course, change the whole system to try to extract even more money out of the companies, which again, all this is systemic, right? You can't have your cake and eat it too. So there's always, somebody needs to put the negative into this equation. Right?
Well, I think there's no question that Bayh-Dole has really been foundational to the innovation system here in the U.S. We've seen an explosion of innovation and all the benefits since passage of the act, and it seems to me that this fits sort of a pattern that we're seeing in different respects with the administration around sort of a different kind or new industrial policy, which really involves the federal government taking, in one way or the other, a stake in the private sector. Whether it's owning a percentage of Intel or a stake in the revenues from NVIDIA selling chips into China. There's a whole range of different manifestations we're starting to see. And, the idea of actually the federal government, retaining an interest in the product of federal research that has been supported by Dole, it seems to be part of a general direction of like deeper federal intervention, but also equity holding in the private sector here, which really seems to be sort of contrary to the historical and very successful direction we've had, but especially around innovation, where I wouldn't have a lot of confidence that these particular directions are going to be supportive of the kind of innovation that has really led our country forward to the global leadership position that it has. So I think, let me look one more time if we have any more questions. This is your last chance, folks out there in the audience, to pop a question up. And if not, we appreciate the questions from our audience. And is there anything else anybody else would like to add on the panel? You've really been terrific. You've shared a lot of insights, but any closing thoughts from anybody? I know we've covered a lot of ground, but there's a lot of ground to cover.
Yep. Nothing for me other than to say thank you. This has been a really nice opportunity to speak on this issue. And at the U.S. Chamber, we're working really hard every day on this, and just appreciate the time.
And and I would thank you very much for including me. I'm not against creative ideas, but not all of them should continue, right? So with just a little bit better filter, and that would be my suggestion.
Well said.
I'll also echo and say thank you so much. And bottom line, if there's one thing that participants take away from Semi's remarks, my remarks in this call, it's to engage on the issue. This is the first discussion that I've been a part of outside of engagement with Coalition in DC, thanks to the Chamber organizing efforts. And also, we're meeting with USPTO and we're meeting with Congress, but they need to hear from more people about the potential implications. So really glad to have the opportunity to engage in this conversation with awesome co-panelists. Thanks so much for organizing.
Thanks, Scarlett. And I think for our audience too, again, we don't know where this idea stands right now, but as John has said, there's plenty of smoke out there. We kind of hope we can help to kind of put down that fire if we can before what's a terrible idea advances very far. So we're going to stay close to this here at the Berkeley Council. Would encourage our members, anybody else who's listening to plug in with us, to stay current on it. John at the Chamber is leading this sort of national conversation, this coalition at the federal level, talking to people in Congress about this. So the next steps aren't altogether clear, but I say feel free to be in touch with us as this goes forward. We'll try to keep you all in the loop and connect you into our panelists in the Chamber if there's next steps you'd like to be involved in. So thanks very much again to our panelists. You've all been great and hugely informative. I hope we could say this is the last conversation of the topic, but it might not be. So we'll look forward to staying in touch and keeping our members in touch too. Thanks so much, everybody.
Thanks so much, Sean.
Thanks a lot.